90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. We have with us Elan Weinreb, who is an expert on alternate dispute resolution, which consists of arbitration and mediation. And he's going to share with attorneys and the general public some tips on how disputes can be resolved through alternate dispute resolution, which include arbitration and mediation. So, Elan, let me hand the mic over to you and just start giving us some overviews as to how parties and attorneys can use ADR to their advantage.
Okay, so I'm going to give you just a basic background in what's now called ODR, which is the evolution of ADR. ADR stands for Alternative Dispute Resolution. ODR stands for Online Dispute Resolution, which has become, it's a subfield of ADR, but it's become much more prominent now in light of the COVID-19 pandemic. And the tips I'm going to give you today relate both to ADR and more specifically to ODR. But generally speaking, from the ADR perspective, even before we get into specific tips for ODR, which involves more technology than anything else as being a new variable, in ADR, the best tip that I could give any attorney to maximize the advantages of the processes, which are both time efficiencies and cost efficiencies, and spoken about this before in a previous show, is preparation. There's no substitute for it. Prepare. In fact, Jerry Spence tells litigators in his book How to Argue and Win Every Time. I have to also be a litigator, so I do this as well. Prepare until you have become the argument. And it's great advice. It's the same thing here, only the difference is that in mediation and to a certain extent in arbitration as well, you're not focusing so much more on a argument perspective or a position perspective as you are also involving needs and interests. In arbitration, this is closer to litigation. There is more of a position focus, but you still want to keep the needs and the interests of the clients and as well as your adversaries, if you can, involved. So at the end of the day, preparation. There's no substitute for that. Now, specifically when dealing with ODR and the efficiencies which are involved, the main efficiency, of course, is technology. People don't have to travel. There's less time involved in preparing and exchanging documents. All of the documents can be exchanged before, which is another tip. If you have any relevant documents, please provide them to the mediator well in advance. And it's extraordinarily useful if the mediator has a background and doesn't have to learn the case on the fly. Otherwise, you would probably have a need for additional sessions unless it's a very, very simple case. Or it's a case which doesn't necessarily involve something which is document sensitive, such as, let's say, a neighbor-to-neighbor dispute regarding a dog or something like that. But if it's anything which involves a contract or anything which involves some sort of document or certainly involved in a commercial case, it's absolutely essential you get the documents exchanged. That can be done by email. That can be done by central repository. You could use Dropbox, again, assuming you take appropriate steps in confidentiality, making sure that all your files for your client, and as well as treating the confidential material from an adverse party are kept in confidentiality. That, to a certain extent, is the mediator's responsibility. Okay,
is it also going to be helpful to the mediator or the arbitrator if each party submits a quick summary of the nature of the facts and the law?
Absolutely.
Involved in that dispute?
Yeah, in most disputes which are complicated, I mean, obviously there are certain disputes where that's not necessary, but in more involved disputes, especially commercial ones, there should be what's called a pre-mediation statement or a mediation brief in the mediation context, which is submitted. The court rules, if you're dealing with court annex mediation under Part 146, they actually require this. The second department, I happen to be a special master as the second department, is in addition to being co-chair of the New York County Lawyers Association's ADR committee, and that involves my involvement also with Part 137. Part 137 is attorney-client fee disputes. So you don't require that, but it's useful to certainly the The documents, though, have to be exchanged. And in Part 146, there is a requirement for the pre-mediation statement as a separate and independent document.
And you also want to have a cover letter or a little brief so that the arbitrator or mediator understands your position.
Correct. I mean, in an arbitration context
of those documents.
Yeah, in the arbitration context, the arbitrator has authority to require actual full-fledged briefing. That's why I'm not mentioning specifically a pre-arbitration statement. You could come up with one, but in an arbitration, it works to a certain extent more like traditional litigation in terms of the procedure in that regard, in that if the arbitrator wants a specific issue of law briefed, he or she can argue it unless by some rare circumstance the arbitration agreement prohibits the arbitrator from doing that.
And many parties are weary of arbitration because it could be binding and they may not want to commit themselves, but they are willing to take a step toward ADR by agreeing to mediation.
That's correct. Yes. Mediation gives the parties a perfect escape route. If they don't like what's going on, they can look. It's like scuba diving. If you ever do scuba diving, you could look up, reach up, and go to the surface. If you're doing open water diving, when you first start learning it, anytime that you want. You can't do that when you're doing deep sea diving because of the bends. And in that aspect, that's the analogy to arbitration. Once you get down farther into the process, as you descend further into the depths of dispute resolution and in terms of being a more adversarial process like arbitration, then you can't just look up, reach up, and get out whenever you want. But in mediation, you have that option.
Let's focus on the mediator for a moment. And you are an experienced mediator. What are the initial steps that you're going to use, the initial tools to try to get those parties to an agreement?
Okay, well, the first thing that you have to do as a mediator is get to know the parties way in advance, or their attorneys for that matter, but way in advance of the actual mediation session. You never want to go into a mediation session cold. Sometimes you have no choice. If you're dealing with let's say a Part 137 program mediation, it's not easy necessarily to contact the parties in advance. It's not always done. But on the other hand, usually speaking, when you're dealing with mediation, you want to certainly interview counsel and the parties in advance, have a call with them, and especially with ODR. And so that's why I'm going to give you, some tips also now with respect to ODR for mediators both, and as well as advocates. And these tips are extraordinarily useful, making the process both more efficient and more satisfying to everybody involved. So the first tip is familiarizing yourself with the technology. Mediators should certainly do this. Right now, your listeners can't see it, but I actually have these tips shared so that you're seeing them at the same time right now, Ken. And if you were having a pre-mediation conference regarding this topic or anything else, let's say it was a legal malpractice case, as whether or not these tips were followed, you'd be able to certainly see it and appreciate it. So that's one of the features of technology. Certainly familiarize yourself with it. As I said before, have an introductory call in the format. Do it in Zoom. Don't do it by telephone and then have everybody come into Zoom. Do a tech check, with the mediators, with the mediator being involved, obviously, as well as the attorneys, certainly at least the attorneys and the clients. And by the way, it's essential that be done.
Okay. We have a lot of ground to cover, so I don't mean to cut you short, but you also want to find out early on, and each party wants to alert the neutral early on if there's any special issues of discovery or of arrangements or anything or the nature of the dispute.
That's correct. In testing out the technology, you would do that at the same time. If there are issues which need to be resolved substantively, that's a good time to do it as well.
I'd like to remind our listeners you are listening to Law You Should Know. Our guest is Elan Weinreb. He's an attorney in Garden City, New York, and he also is an experienced mediator and arbitrator. He also appears as an advocate in disputes that are resolved through mediation and arbitration, and also, of course, through the courts. If you missed any portion of this show or want to hear other shows involving Elan or any of our other guests, please go to our podcast at mccradio.org. Elan, just to move fast forward to the dispute, how is the mediation or going to start out? What should each side do, and what does the neutral want to accomplish?
Okay, so in terms of the process of itself, it's really up to the parties, because mediation is a party-driven process. So if the parties decide amongst themselves who wants to start first, it's not like litigation where there's a set order where you have plaintiff defendant, and then ultimately the parties have a certain closing order at the end of a trial in terms of making their closing statements or even to a judge. It's very much driven by the parties' process. But to summarize the entire mediation process quickly, there's an acronym called BADGER, and it was derived from Professor Joseph Stolberg. It's found in Taking Charge of Managing Conflict at page 58, but also Professor Leela Love from Cardozo uses this in speaking about mediation informally. The acronym again is BADGER, like the animal. The B stands for beginning the mediation, meaning you come up with an introductory statement and you lay the ground rules for how the parties are going to interact, which they have to agree to. The A stands for you accumulate information. That means you take your case statements, what the parties' positions are, and then you're going to try to move them towards needs and interests from those positions. As a mediator, it's much useful to focus on them for reasons I'm not going to get into now. That has to do with mediation theory. D in DOG stands for developing an agenda, meaning the issues to be discussed. That includes the needs and the interests of the parties. From there, you move to G, which is generate movement or options, meaning that the parties are going to be coming up and brainstorming with various ideas for how they could potentially resolve the dispute. And then if you are asked as the mediator to give what's called a mediator's proposal, sometimes you can step in there. But again, you want to try to have the parties do the G part themselves. E stands for escape to caucus. Caucus is a private session where very often people think this is shuttle diplomacy, where the mediator goes between one party to the other party in various rooms, which you can do now with technology in breakout rooms in Zoom very easily. And then the E, all the reasons for caucus breaks down to you want to explore settlement options, signal some sort of warning signs if you feel there's a power imbalance, confirming movement. A is attack the recalcitrant parties' positions in terms of giving them a reality check. Sometimes parties are completely unrealistic. It's more of an evaluative mediator tactic. P, pause just to take a break from the mediation, and E, evaluate. That's what escape breaks down to. Again, evaluating is done as always a last resort, usually in mediation, but it can be effective. And R is then finally, at the end of the day, once you've done all of that, resolve the dispute, have the parties come to an understanding, then potentially reduce that understanding to a writing, but better yet, have the party, or if the parties have attorneys, specifically have the parties' attorneys do that.
Okay, I just want to focus on the G and E because our time is limited here. If you are the mediator, you've heard the agenda, you've heard the nature of the dispute. And some parties, of course, may feel more comfortable talking to you alone in private. And this way, and also, do you feel it's a good idea for the mediator to give them some feedback as to how to come closer to a resolution?
Yes,
in that private caucus?
Yeah, if depending upon how things go, that's the mediator's job. But again, it's the idea is to try to get the mediation parties, the parties who are involved, to do that themselves. The mediator is a guide.
But what if they're afraid of showing their bottom line, or they want you to give them a suggested straw they can offer to the other side?
Yeah, if they say that and you feel comfortable in terms of the way you're going in, again, you have to, as a mediator, be impartial. So it's important to make sure that you're always appearing to be impartial and appearing to be neutral. But if you could do it in such a way that you're not giving them a suggestion based upon their direct interests, but instead you're saying, this is something you might want to consider, or this is something which is out there in terms of the variables. For example, right now, cases involving medical malpractice, when you have doctors who are going to be involved, let's look at the environment pre-COVID to post-COVID. Now, doctors, and for the most part, are heroes, and they should be. They are. I mean, it's not just a perception; it's the reality. They're doing tremendous work, and we're grateful to them. But at the same time, it implicates our understanding and how we treat them. And in terms of the dispute, that could very well be a factor going forward in terms of the.
Well, certainly to a jury, but yeah. So you're going to the parties are going to give you. One party says low pay, and the other party says they want a lot of money. How are you going to develop some movement?
In that particular case, what you could do is a case where you would have the parties go through what's known as risk assessment, where you would set up what's called a decision tree. It's a diagram which can show whether a party is going to have a certain percentage of an outcome. It basically deals with probabilities as to how a party's case can be evaluated. You take the sum total of the probabilities and work backwards from what could be a final outcome. For example, in the appellate division, when we do cases like that, we work from the possibility of a remand and a full trial. We work for the probability of that going all the way back to where the case is right now at this point. And then you mathematically analyze each one of those variables so that you could adjust the party's expectations as to what the reality of their
do you think there's also a process where the advocates, let's assume the attorney, are educating the mediator about those numbers, about their strong points based on the facts of the law?
In terms of
at the mediation, is each party trying to educate or influence the mediator to the merits of their position?
Well, that's going to happen no matter what, but the trick is, of course, for the mediator not to be spun. I mean, that's a very dangerous situation, is where you have a mediator ultimately crossing over to decide, in terms of his or her understanding of the case, which side is right. The mediator should never be doing that. That's something which is very important. Educating is one thing. Certainly you want the mediator to be educated and you want him or her to understand all the variables, what's going on, but you never want to put the mediator in a position where you're sort of turning them, because then it's no longer a neutral, impartial process. Then you have essentially an advocate who's been assumed for one side, and that's not good for the process at all.
Is it best to start with one point or one subject or one aspect to see if you can generate, as a mediator, if you can generate some agreement on that issue?
Yes, that's the concept known as partializing. It's actually one of the techniques that Bob Collins uses and is part of his program, or alternatively known as divide and conquer. It could be used in many different ways. You could take one particular large issue, let's say family dynamics and family mediation, and then break it up as to something very specific, such as how holidays should be treated, and then put everything aside, especially if you think as a mediator that that's a easy area to resolve, or alternatively, if you think it's a difficult area to resolve. It really depends upon your take of the situation, and there's no hard and fast rule for it, but as a tactic, it's very useful.
Do you also try to do that with the facts in a commercial dispute, or let's say a negligence, a tort dispute?
Well, the facts is sometimes it really depends upon the case. I wouldn't say so much we do that with the facts, but with individual causes of action. For example, if the parties can agree on the commercial side that if X, Y, and Z occurs, then there's no, I would say, legal basis for claiming causes of action 4, 5, and 6, because they would then, in those circumstances, would be duplicative. You could do it that way as well. I wouldn't say you necessarily do it with the facts, because the facts have to be taken as a whole, usually most in commercial cases, but you could do it with the legal contentions.
What other strategies would you suggest to the neutral to try to bring the parties to yes? Okay,
so amongst the other tips that you have for going through mediation, and that there are many that are out there. One of the best ones that you have is something called log rolling. Log rolling is a tactic in which you essentially trade something of low value to one party for something of high value to the other party. And by doing that, you get the parties to ultimately see that they're getting the most value. The trick in getting the parties to yes, which is also the name of a book, it's a very famous negotiation book, Getting to Yes, William Ury and others. The trick is to try to get them to feel that they're getting the most value and ultimately getting what they want. And if you do that by log rolling, is a great way of doing that. You're giving something of low value from one party to the other party, which they consider to be of high value, and that is something which works very, very well.
And also behind that, you're getting one party to give up something they don't, that is of low value to them, but of high value to the other party.
Correct. Right. Exactly. That's what ends up happening. So, for example, if let's say you have 3 classes of assets, you could have a house, you could have a business, and then you could have, let's say, some personal property, separate and apart from both of those. If the personal property has sentimental value to one party, that's going to be putting it into the high category. If, let's say, the party really doesn't care so much about the business aspects of what's going on, you have that in the low party. You could trade one for the other, and sometimes that will be very effective, because then the parties feel that they're getting their value for what they want.
And how do you eventually move to other issues and try to bring the parties closer?
All right, that's ultimately based upon getting the parties talking, because when you have, as I said before, positions, that very often parties come into. The problem with positions is that they are very static. And what do we mean by a position? Let's say a person says, I need to have this particular property in this particular location. I need to have that. I can't either be forced to give it up, or alternatively, I need to be able to acquire it. One way or another, it has to be in my possession. The problem with such a stance like that is that there's very little variability. If on the other hand, the party says, I need to own real property somewhere, or I need to just be invested with value, I need to be sure that I have at least this amount of money to be able to send my kids to college and fill in the rest of the blocks, that's already a need. And then you have much more variability. What assets does the other party have? Can we work with something? Can we adjust something? Let's expand the pie. That's what you want to play with, what are called expansive negotiation variables as opposed to distributive negotiation variables. And that's the way to ultimately get the parties to yes, is to break them out of their position prison and start to let them see that there are many more options which are available to them. The more options you have, the more versatility you have. The more versatility you have, the greater the prospect of resolution.
Okay, we're going to come back to your strategies in a moment. I just remind our listeners, you're listening to Law You Should Know on 90.3 FM, the voice of Nassau Community College in Garden City, New York. We're talking about strategies for a successful mediation, or perhaps an arbitration as well. Our guest is Elan Weinreb, and he is a mediator and arbitrator and also acts as an advocate for parties in traditional court setting or in a mediation or arbitration. If you missed any part of this show or you want to hear other shows about the law, please go to our podcast at nccradio.org. Elan, you were talking to those discussions about various issues of great importance or where there can be room for movement. Should they take place separately between the neutral and each party rather than getting one party emotionally upset, listening to it, and maybe they've already discussed these issues without success with the other party directly?
So that's what we talked about before with caucus. And generally speaking, yes, those are situations when you want a caucus. When you have to do risk analysis, as we said before, when you're dealing with the decision trees and getting percentages, you almost always want to do that in caucus. Unless the parties are extraordinarily mature and very even-keeled in terms of their positions, and you're dealing with people who really are focused more on the needs and the interests at the time, it's very rare when you're dealing with that type of dynamic, when you're dealing with positions and how things are going to pan out. Unless you have a situation like that, which I've only really seen once in my entire career, then you want to have the parties in caucus in separate rooms.
And also, when you're doing the caucusing, do you want to speak to the attorney alone, or you want to speak to the attorney with the party?
That really depends upon the situation. If you have a client, a party who is particularly emotional at the time, sometimes it does certainly help to speak to the attorney privately, because then you could tell the attorney, look, you have to tell your client that maybe it's something that he or she doesn't want to hear, but ultimately sometimes these are the facts on the ground, and this percentage is probably going to be higher or lower than what you originally might have thought. Sometimes, however, you want to have the client there because sometimes they feel that you as the mediator may very well be ganging up on them by speaking outside their presence. There's a certain amount of psychological tension and apprehension that goes on whenever you call a caucus.
And that's very important to help reduce that tension, for the neutral to reduce that tension and know how to reduce it, such as I'm sure you do. Do you also want to give the attorney, let's say, a heads up and then talk to the attorney about whether the client wants to hear the bad news from the neutral or the attorney wants to convey it to them?
Yeah, I mean, in terms of the process itself, usually speaking, the attorneys are savvy enough to know, based upon emotional cues or just based upon what's said, and even just based upon watching body language, that it's time to call a caucus. And you tell the parties that at the beginning as the mediator in your introductory statement. You tell them anytime you want to break, it's not a deposition where there's a question pending and then you can't take a break. Anytime anyone wants a break, anytime somebody wants to call a caucus, you call a caucus. That's the way it works. It's a voluntary process.
So it's good to let the attorneys and the parties know they're in control to the format or how things will evolve in this dispute resolution.
Yeah, and to save time, what I do as part of my practice, and I think most mediators do as well, is certainly in the commercial context, they put into their agreement various ground rules. And in those ground rules that we were talking about before, you explain what options the parties have. So aside from just the ground rules, which are more prohibitive or restrictive in nature, like not interrupting a party when a party is talking, except the mediator has a privilege usually to override that, the other ground rules are that the parties are vested with the ability to call a caucus whenever they want, and they have the ability to, certainly ask questions and explore any topic as long as they're not attacking another party personally.
So you, as the neutral, are running the proceedings. You're in charge, but you're giving the parties more of a voice and more control of the proceedings. It's certainly something they would not have in court.
That's correct. The parties' goals in the mediation ultimately are to advocate, and as well as their attorneys, they advocate for their various interests and needs. The goal of the mediator is to facilitate the resolution of the dispute or exploration of those needs and interests towards that end, but more importantly also to safeguard the mediation process, and for that matter, if you're dealing with arbitration, the arbitrator has that duty as well, is to actually safeguard the process itself. The integrity of the process, the quality of the process is of paramount importance, so that always has to take precedence.
We're running out of, we're short on time here, but as the mediator, you've resolved some issues, you're moving on to others. Is that how you generally do it? Go from issue to issue and save the toughest for last, or put the toughest in the middle?
That depends upon the parties. Sometimes it's very useful to start with an easy issue first. It's almost like chipping away at something which is more of a problem, like a sticker. You're peeling a sticker from a envelope, and you need to move from one envelope to another. I like to think of that analogy because you have to move very slowly. You can't just rip the sticker right off, because you'll rip the entire sticker off. It'll go and be completely destroyed. What you have to do is you have to very, very methodically move with something, and that's the analogy over here. Start with something easy. Do that slowly. Get agreement on that. Move the sticker up. Get some progress. Let the parties see the progress. Once the parties see the process, that starts snowballing them, starts motivating them because they have that agreement and they can move forward. On the other hand, sometimes parties come around and they say, let's deal with the elephant in the room first. I want to get that off my chest. I need to get off my chest. I can't think otherwise. If that's the case, you deal with that first.
Okay, and also, is it okay to have a timeout or an adjournment so that each party can sleep on it or do some research if they need to do it about certain numbers or certain other information, and continue at a later date?
In some of the ODR guides, I mean, I have one which I'm showing you on the screen. You have a tip to build that into the process itself, where you want to take frequent breaks. There's something called Zoom fatigue, where people are involved in Zoom conferences the entire day, and that in itself can get them, never mind just the emotional aspects of the dispute that are going up. So sometimes you want to just build breaks into the process. And and certainly there's no requirement that a mediation, unless the parties have a specific requirement or a time factor, but there's no requirement of the process itself that a mediation has to be accomplished within a specific time frame.
Okay.
Ken, I want to close just by giving some quick tips on ODR, online dispute resolution, that's been evolving in light of COVID-19. And just to go beyond those tips which I gave before, first, you want to raise any sort of possible interruptions to your technology in advance. If there's people who have dogs or kids in the background, it's very important that they address those before mediation sessions occur. The other thing is you want to respect everybody's privacy and confidentiality, so you want to make sure that there's nobody who's going to be from a third party attending a mediation session or an arbitration session, and certainly no recording or coaching of answers in an arbitration. And finally, always have a plan B. You should always agree in parties in advance about what to do should you have technology failures, because especially in the summer with thunderstorms and what else, they're inevitable. They occur at a regular basis. The only guarantee that I certainly can give to anybody is that at some point in any given mediation or arbitration conducted by ODR, something is going to go awry or something's going to go wrong, and you have to know how to deal with it.
Give us your contact information again.
My firm name is the Weinreb Law Firm, PLLC. You could find it at www.weinreblaw.com. The W is in William, E in elephant, I igloo, N Nancy, R Robert, E elephant, B boy, LAW.com. Phone number is 516-620-9716. And I'm in Garden City.
Elan is willing to answer a question if you have about the mediation process or a particular aspect of mediation. As you also have heard through these programs, he's an expert, both arbitration and mediation. Certainly because of COVID, they're another tool to resolve legal disputes. If you missed any portion of this program, you can find the podcast at nccradio.org. We've only given general information, But if you want to use ADR, make sure you tell your attorney that, and if the attorney is not willing to consider that, perhaps consult with another attorney. Please join us next week at the same time here on 90.3 WHBC, the voice of Nassau Community College, for another program on Law You Should Know.